Playback speed, 1.25, already done. We nailed it today. It's like I'm a professional today. Hi, Ariel. Okay, that was crazy. Hi, Lori. That was a crazy stream. That was crazy. Now we have to go back into OJ. The defense started in July. They start their case in chief in July. We are in May. Okay. So let's just look at like the length of videos we have. So these are all 2 hours long. These are mostly all 2 hours long. So we don't have that one's only 1 hour. We don't have that one's only 2 minutes. That one's only 1 hour. That one's only 1 hour. That one's only 1 hour, 1 hour. Okay. So this is May. June, I think we get Marsha back up and Shek. Definitely get more Shek coming up. There's nothing, but there's Marsha. I see her in a couple places. I don't know exactly when in July, or we do. We also have a couple lawyers we've never seen before come upcoming, which aren't showing up now, but trust me, there are. But this is July, so this is how much further we have to get until we finally get to the defense's case in chief, which I think everything will go quicker. You know how, time goes faster in the second half of things than the first half. So we're gonna get to the defense's case in chief really soon. Weeks. That's really soon in OJ time, right? Oh no! This is okay. So this is what I was trying to show you. We get some interesting lawyers. This lawyer comes up for a bit. I don't know who he is. Marsha comes up for a bit. I don't know who he is. Then Shaq comes back, which will be freaking fun. Then Marsha comes back. I see Cochran come up for a bit. So then we get to July. July is right here. That's how far we have to go. I started it. The very first thing I said, Fozzie, was the speed is 1.25. Task completed. Oops. We're almost there. We're almost there, guys. We're almost there. And now that I remember to do 1.25, we'll get there way faster.
Say most probative, you mean what? Ones that answer the questions. Ones that if there's multiple people bleeding at a scene, that we are getting blood from multiple people and not just from one. Whatever is necessary to get the most appropriate or the best information out of the evidence that's left at the scene.
Now, is this idea of using selectivity in collecting evidence one that is discussed in some forensic science literature?
Yes, I'm aware of it being discussed elsewhere.
And specifically, did you look at the discussion of this idea in Henry Lee's book on crime scene identification, the one that I always refer to as? Look at the discussion of this idea in Henry Lee's book.
I've seen that information in his book, yes, that you need to be selective in the samples that you collect.
And I'd like to just show you one portion of this book and see whether you've taken a look at it. It just has big print. That's the big print book. You recognize it?
Yes,
I got big print and I cannot lie.
Yes,
What?
referring to the page, referring to the size of the
We're
print.
referring to the size of the print. It's big print. It was my idea of a joke. Okay.
You're obviously not at the age where you need bifocals.
Yeah, well, I'm getting there.
You may.
And directing your attention to page 79, the first full paragraph. Maybe you could just read. Have you considered that paragraph? Have you read that before?
Yes, I've read it before.
Maybe you could just read what Dr. Lee says about collecting evidence where it starts recognition and, well, maybe just starting there through the rest of the paragraph.
Recognition of evidence involves
Is there a
selectivity
question?
and a general understanding of logic of crime scene. If all objects at the scene are collected and submitted to a forensic laboratory for further analysis, the forensic facility will be overwhelmed. If critical evidence is omitted or improperly preserved, the use of sophisticated equipment cannot salvage the investigation. Hence, correct crime scene search and collection methods are of paramount importance.
Okay, so basically, it's a balancing act between not wanting to overwhelm the laboratory with too much and not wanting to miss the relevant evidence.
That's correct.
Now, with respect to the Bronco, well, I'll get into that later. Have you heard some testimony to the effect that in this particular case, that there were 5 stains at the Bundy location, all of which were collected, whereas there were 3 stains at the Rockingham location, A, B, and C, that were not collected?
Yes, I have.
And is there, from a forensic science standpoint, in terms of crime scene identification, based upon your understanding of the evidence in this case, any reason for that?
There's my understanding of it, yes, there's an explanation for
What
that.
is that?
Well, in the case of the items that were collected from Bundy, that was the crime scene. We had 2 victims there, and there were blood droplets that appeared to be inconsistent with having come from either of the victims. So they would indicate somebody else that had been present at that location. At that point, it makes sense to collect as much as possible of that, keeping in mind what I said before. If it had been extremely long, I would have expected them not to collect all of them, but to collect a good representative sample of what we have there as far as the blood goes. As far as the other location at Rockingham, that was not a crime scene. It was another location that may or may not have been involved, and they used a little bit more selectivity there, collecting a stain at the beginning, at the end, and leaving some of the ones in between in place.
Your understanding is that there was no body or evidence that a crime actually occurred at that location?
That's correct.
Sustain or phrase the question.
Is it your understanding that there was no body or evidence that a crime actually was committed at that particular location? Homicide.
Sustain.
Oh, that's okay. I'll withdraw the question. Now, did you also hear some evidence to the effect of I'm not sure if it was triangular, but a little corner piece of paper that was in the area of the entrance to the caged off area not having been collected?
Yes, I have.
And what is your view on that?
As far as I'm concerned, if it,
Sustain.
Should that have been collected,
yes.
and why?
The area that we were talking about as far as this crime scene goes is a fairly limited in size, and not like, again, using an example, if the crime had occurred in an alley where there was a lot of debris, a lot of trash around, then some selectivity should have been done as far as collecting. You're not going to collect every bit of paper, every bit of trash that's in an alley. This particular area, though, was smaller. I would assume had some maintenance done on it with some regularity, possibly cleaning up. A piece of paper in that location kind of stands out as being potentially involved somehow, and had the criminals been aware of its existence, should have collected it.
Okay. And could the failure to collect that item have in any way affected any of the other biological evidence, some of which you tested in this case?
No, not in any way.
While they're looking for that, let me go on to another topic, and then we'll come back to it. Does the Los Angeles Police Department use plastic baggies or plastic bags for the purposes of putting the wet swatches until they've had an opportunity to dry them?
The plastic baggies are used to transport the evidence, yes, until they can be taken back to the laboratory, opened up, and allowed to dry.
And how long has that procedure been used?
Well, that's the one that I learned pushing 17 years ago, so it's been in use at least that long.
And during the 13 or so years that you were involved in the serology, is that right? Was it approximately 13?
Yes, approximately 13 years.
What effect, if any, did you observe on that collection technique, on the evidence that you were actually testing?
Well, considering it was the technique that was used and was a standard technique in our laboratory, and we would, with regularity, analyze evidence items that would give us good typable or identifiable results, I would have to say that the use of that technique was appropriate and effective for bringing samples into the laboratory for analysis.
And during the 13 or so years that you were in serology, did you notice any particular problems in terms of evidence being degraded to the point where you couldn't get results?
No, there's not a ongoing problem at all with degradation that I can relate back to the bags. Occasionally, we would have a piece of evidence come through that had been allowed to stay in the bag, and that's very inappropriate. And that would show us problems with that evidence.
Under what circumstances would that happen?
If the person forgot to take it out, if they were not properly trained, that would happen sometimes with the detectives. It just is a situation that would occur, though, very rarely.
Sometimes when detectives were collecting some of the stains.
Occasionally, but rarely.
And in those instances where it was not taken out of the bag to dry for an extended period of, well, when you say extended, what do you mean?
I mean, as far as ultimate packaging, where it then gets put onto a shelf and is left for, anywhere from many days to months.
You mean you would have situations like that occasionally with detectives?
Where we'd see a blood sample still left in a plastic bag? Yeah. Occasionally, but rarely.
And what happened on those samples?
Normally, they were degraded. You wouldn't get false results. You just get no results.
What do you mean you wouldn't get false results?
Well, except for a very unique or specific situation, degradation of a sample doesn't change the type to another type. It just makes it so you don't get any information at all.
So when you say no information, when you do your test, what do you come up with?
No result. Nothing. There's no typeable result that's obtained.
So in that particular instance, if the perpetrator's blood has in fact been lifted from a crime scene or a crime location, and the results have been degraded to the point where you don't get any information, would that benefit the perpetrator?
Sustained. Rephrase the question.
Would that cause the perpetrator to be falsely included as a possible donor of the stain?
No, it would not.
Could it cause the perpetrator to be falsely excluded?
No, there's no information there at all. It just wouldn't provide any forensic information.
Okay. Now, let me just go back to this photograph. I'd like to mark this photograph as People's 205 for identification of what appears to be the little piece of paper. I think it's depicted in some other photographs. Now, I'd like to show you 205. Is this your understanding of the piece of paper? Any questions about?
Yes, it is.
Okay. Can we see that? All right. And is this piece of paper, you said that you would have collected if you've been out at the crime scene?
If I was aware that it was there, yes, that's one of the items.
Assuming it hadn't been covered over by a blanket or some other item, and you'd seen it.
If I'd seen it, yes.
Now, is this the kind of thing where there's a hard and fast rule that you should collect it, or is this the kind of thing about which reasonable forensic scientists could differ? I mean, how would you characterize it?
When it comes to what to collect, there are very few hard and fast rules. That's what is acquired with experience, the mental picture of what you collect and what you don't collect. So as far as a hard and fast rule, whether or not somebody should collect it or told to collect it by a manual, no, that doesn't exist.
Okay. And in your estimation, Mr. Matheson, if this particular piece of paper were located in an area where there was fairly extensive pooling of the victim's blood, would this be the kind of evidence that you would want to test for biological evidence showing the victim's blood type?
They were using yellow
I don't
solo
believe I would
cups.
recommend this particular item
That
to
one
be
looks red.
tested for the biological evidence on it, particularly in light of other evidence that was collected.
Okay, thank you.
You know what? He's doing a fan-freaking-tastic job of just destroying the defense, which makes me even more confused because I know the outcome.
Now, going back to the issue of collecting, why would you not recommend that be collected for tested for biological?
Rephrase that.
Why would you recommend that piece of biological evidence or the biological evidence on it not be tested further for genetic markers?
Well, like I just mentioned, you have to look at the whole scene, and we do have other items of biological evidence that provide information as to what possibly occurred. This particular one being found in close proximity to the victim, being heavily blood-stained, at some point we do have to make some assumptions, and the assumption would be that the blood that's present on that is coming from the victim herself. At some point, if it really seemed necessary or if there was a lack of other evidence in the case, we may want to go after and analyze some of the individual drops, but it would be a low priority when it comes to that.
just wanted to show one of the overall photographs of the crime scene that's already been marked. Show him people's picture. It's 43 feet, and I guess this is it's a bloody photograph, but so the court might want to cut the feed. Sir, showing you what's been previously marked as People's 43D. In this area of the pooling of the blood, how much, if any, of that blood on the sidewalk, it's not a sidewalk, in this walkway, should be tested?
On that particular location, very little of that blood. It is common sense does come into play when you're picking and choosing which items to analyze or which items to collect. And common sense would tell you that by far, if not all of the blood that's visible in that picture is coming from the victim herself. I would want at least one sample or item of that blood to be collected as a standard of the victim. But
and if the evidence showed that the piece of paper were found in what would be the upper right-hand portion of the photograph, would that location be consistent with the answer that you previously gave about why you would not want to test that necessarily for biological evidence?
that would be the
Sustained.
Is there anything about the photograph and the placement of the object that would relate to your answer previously given us to testing the piece of paper for biological evidence?
well, given the location of that piece of paper and the way it's heavily stained, I wouldn't say that we'd never test it, but it would be a very low priority.
Okay. Thank you. Now, getting back to the issue of collecting stains, have you looked at the Los Angeles Police Department manual, specifically section 52520, as to the booking of biological evidence?
Yes, I have. I've looked at a number of manual references. I'd like to make sure that the one you're talking about is the one I'm thinking of.
I'm just going to show this to refresh the witness's recollection. So showing you a section of the Los Angeles Police Department manual. Do you recognize that?
Yes, I do.
And specifically 52520 talks about preserving wet stains.
Yes.
And does that state in the second sentence that plastic containers or plastic wrap shall not be used as a packaging material?
Yes, it does.
What is your understanding of that requirement?
Well, the operative term there is packaging. We teach, and in consistency with the manual at that point, say that biological evidence should never be stored or packaged for permanent storage in plastic.
Now, when you say packaging, final packaging, what are you talking about?
When the items are submitted to our property division for storage until such time they're analyzed.
Okay, I'll get into that a little bit more later. So in terms of the usage of plastic bags for transporting a stain from the scene to the laboratory when it's dried, within the forensic science community and amongst serologists, is that one acceptable technique for collecting a stain?
Yes, it is.
Now, does the Los Angeles Police Department, let me just ask you another question about the manual first. Is this manual, the manual provisions dealing with the booking of evidence, are they up to date?
No, they are not.
In what manner are they not up to date?
Perfect example is we currently have within part of SID a property room that's called the Evidence Control Unit, and we have a courier system, which are light duty officers that travel throughout the city at night, collecting evidence from the different stations and bringing them down to our Evidence Control Unit for final storage. Both of these functions have been in existence for at least, I believe, 2 to 3 years, one of them longer than that, and there is no reference to either one of them that I'm aware of in the manual.
In other words, there's no reference to this new evidence control unit that you have at SID in the manual?
That's my understanding, yes.
Okay. And if a piece of evidence is collected from a crime scene, biological evidence, in a manner that's forensically accepted, but the manual provisions have not been updated in such a way so as to authorize that particular collection, would it affect the outcome of the test?
Oh, first off, I'd rather they followed the proper procedure rather than following the manual.
Okay.
If that is the way that we're doing something, then it's better to use a procedure that's going to give you the best results than a reference in the manual that may be outdated.
Now, with respect to the crime scene truck, is there a refrigerator in the crime scene truck?
Yes, there is.
And what kind of materials are stored in the refrigerator?
Mainly it's chemicals, particularly chemicals that we use for field spot tests.
Would there be any problems in storing biological evidence in the refrigerator?
Any problem with it?
Yeah.
No, there isn't a lot of space, but there wouldn't be a problem with it.
What about spillage? Is there any issue concerning spillage of these chemicals onto the biological evidence?
Ultimately, that could be a problem, but we don't have a lot of spillage in them, but we do carry chemicals in there.
Now, is there any rule that you're supposed to use the refrigerator when you're collecting a stain?
No, there is not.
What about with respect to the whole blood? When whole blood is collected and a criminalist comes into possession of it, does that whole blood that's taken as a reference sample have some preservative in it?
Yes, it does.
I'd just like to show you what's been previously marked as Defense Exhibit 11, 1112, and 1124 for identification, 2 purple top tubes. Do you recognize those items?
Yes, I do.
What are they?
They are 2 samples of 2 different brands of blood collection tubes.
What's the significance of the purple tops?
The color of the top of any tube indicates the preservative or anticoagulant that's present inside of the tube. Purple happens to pertain to something that goes by the initials of EDTA.
Do you use purple top tubes in the laboratory?
Yes, we do.
And do they come from the manufacturer with EDTA in them?
Yes.
What does it do?
I'm not sure if it is just a anticoagulant or if it's an anticoagulant preservative, but it helps the blood to stay in such a condition that it's appropriate for typing.
And is it critical if you have an EDTA purple top tube to refrigerate that reference sample immediately?
Not immediately.
Okay. How long can you keep the purple top tube out, or should you keep it out before you refrigerate it?
I don't know if I know of any particular, specific time frame. I would like, personally, I would like it to get into a refrigerator as soon as it's possible. However, I do know that we get legitimate results if it's not placed in the refrigerator as soon as possible. So I don't think I can give a specific time frame on that.
What happens if you get a reference sample from a living victim or a living defendant? The defendant has to be living. And the activity from the tube is lost, genetic activity.
Well, in that situation, it creates a little bit more paperwork, I'm sure, but the source of that blood is still available. We can get an additional 2.
Okay.
All right, Mr. Goldberg, would this be a good spot?
Maybe I could just ask one more question to tie this up. Okay. And what is the effect, therefore, if the genetic activity is lost from one of these tubes?
Well, if it is lost, then the information from that particular tube is no longer available to us. However, if we can get a additional sample from that individual, the results would be exactly the same as from the first tube.
And what if you couldn't get an additional sample from the individual? Would you get a false inclusion as a result of a blood vial having degraded?
No, you wouldn't get a result. There'd be nothing to compare the information from your evidence items to compare it to.
Similar to the case of a dried stain taken from a crime scene.
Sustained.
Well, is that similar to the explanation that you previously gave when we were discussing the stain taken from a crime scene?
That's correct. In that if you lose the information, it just there isn't anything there to compare to. You do not make then erroneous comparisons, inclusions or exclusions.
And in this particular case, were you able to test and get results from the reference sample that came from the defendant?
Sustain.
Did you test the reference sample, in this case, item number 17?
Sustain.
I didn't hear grounds.
Foundation.
Okay, I'll take it up. Maybe we can take it up.
All right. The person whose cellular telephone went off is ordered to immediately surrender that telephone.
That happened yesterday too.
In this section of the courtroom.
Tase him. Yay, Anna. How's she feeling? Hi, Richard. Hi, Wildfire.
If I don't get a response from anybody, everybody's going to be searched coming in and out of the courtroom for the presence of cellular telephones and pagers. We've had enough problems with this. We've disrupted these proceedings 6 times already.
They know. That person knows it was them. They just do.
I don't want to have to order the bailiffs to search each individual person. So the person with the cellular phone.
Everybody around that person knows too. Who looks the most nervous?
All right, bailiffs are ordered to search each individual entering the courtroom. No pagers, cellular telephones, any noise-making devices may be allowed in the courtroom from this point hence. All right, we'll be in recess. 1 o'clock.
One bad apple.
Doesn't matter. All the parties are again present.
Sorry.
Mr. Blazier, when we recessed, you indicated that there was something
Richard,
about,
you say that every
we had one other
day.
issue, one of the boards that you had an objection to.
Actually, now there are 2 issues, Judge. They just brought another board in.
All right, well, let's take a look at the first board.
The fingernail board.
Did he just say the fingernail board? Is that what he said? Maybe I heard wrong. I'm old.
In this manner, so it's
Yes.
People's Exhibit 42, which bear the frame counter number 0039. This bears the frame counter 0040. See the two photos.
No, I recognize the scene that's depicted there. All right, Mr. Goldberg, why do we need this?
What?
Why do we need this?
The reason is that this goes back to the EAP issue. As the court recalls, the defense made a big deal in the opening statement about someone else's blood being found under Nicole Brown's fingernails, and we're going to address that in some great detail. The court and knows that one of the things that we want to do in order to do that is to put on evidence as to the testing of item number 42, which is the blood underneath Nicole Brown. And what I want to be able to show here is why it was reasonable from a forensic science standpoint to make an inference about the results under the fingernails from the results on the pool of blood. I want to show that they are in contact, that she is lying in that area, and that the blood that Mr. Matheson tested, item number 42, is subject to the same environmental conditions and was deposited on the crime scene at the same time, presumably, as the blood underneath the fingernails.
So you're saying the relevance is the location and position of the hands from whence the nail scrapings
Yeah,
come?
in contact with the pool of blood. And then the relevance of the hands themselves is the close-ups of the hands, which I believe may also be in evidence, according to Mr. Glazier, is that they do the same thing. They're showing that this is all really part of one contiguous and continuous blood source, and therefore we can take test results from a variety of locations in that source of blood under the fingernails and interrelate them, trying to figure out what's happening to the items underneath the fingernails.
All right, Mr. Glazier, do you have any response to that?
Just that the jury has seen these pictures over and over and over again. You can't even see item 42 in any of these pictures. I think it's irrelevant and cumulative and prejudicial.
All right. The court finds that in this particular context, the location
That
and position of the hands
is hilarious. They're complaining about cumulative? Is that
relative to the crime scene itself, the pool of blood, and the location of Nicole Brown Simpson as she was found, that there is significant probative value with regards to the nails, clippings, and scrapings, and that the jury has already seen a similar picture to this in a relevant context. I don't think it will have the inflammatory effect that counsel argues, so the objection will be overruled. All right, what's the second board?
There's a new chart that just was brought down at 1 o'clock, I believe, and it concerns testing by the defense. And this is an issue that we've talked about a number of times before. We're waiting for a ruling from the court on issues related to these items on this board, I believe. And we have items during the period of time when we had possession of them. There is virtually no probative value. Clearly, there's a prejudicial effect to what they want to do. We strenuously object to any testimony concerning what happened to items when they were in our possession or what didn't happen to items.
Your Honor, with the court's permission, maybe Mr. Harmon could address this because he's going to use this with one of his witnesses and mine in order to establish the authentication for the exhibit.
All right, let me ask you, though, Mr. Goldberg, before you go, one question. When do you anticipate using this?
I'd say I probably have about an hour and a half worth of material to cover to 2 hours is my best guesstimate prior to this board.
All right, Mr. Harmon?
Your Honor, remember we proposed a stipulation that would accomplish what this board accomplishes, and it's kind of disappeared from everybody's agenda. This board is our attempt to utilize the provisions that you made in your order on February 8th. They would like everybody in the world and this jury to think they never tested any evidence in this case, and that's simply not the case. They took part of our samples in October. They did not have writing on them. That was pursuant to the court's order. Mr. Matheson can lay the foundation for that being turned over. When they came back, they had all these names and dates all over them, and that's the subject of what we're going to discuss Wednesday afternoon, but it's also contained in the stipulations. And so, absent them stipulating to a very sanitary, you took our evidence, you brought it back, you consumed part of it in the testing, which is what you afforded us the opportunity to do. We have to prove it. And this is one way that we begin proving it, Your Honor.
Mr. Glazier?
The critical phrase there is consumed in testing. We've stated from the beginning we have no objection to the jury being told that the reason there's half of 3 swatches missing is because it was provided to the defense. The jury needs to know nothing beyond that. Mr. Harmon wants to get into what we may have done in a confidential, privileged basis where he wasn't there. He doesn't have the foundation to go into that. He wants to raise some sort of specter that because we've tested evidence that we got results we didn't like, which is
So your objection is characterizing it as having been used in testing rather than just having been given to you for whatever purpose you deem appropriate.
Correct.
So if the court's instruction to the jury is that on such and such a date, this item, for example, item 47, the possession of which was given to the defense, that a certain portion of that was removed and given to the defense, and then the remainder returned to the prosecution on a subsequent date, you have no objection to that?
No, no problem with that at all.
All right, then you would have, I take it, then no objection if that is the limitation on the testimony here with regards to these packaged items.
Well, I would object to the introduction of these large photographs of the packaged items with all sorts of different signatures on them that presumably Mr. Harmon is going to feel the need to explain to the jury where they came from. Nothing is added by this chart that isn't conveyed to the jury by what you just said, what the court just said.
All right, Mr. Harmon?
Well, we've been pussyfooting around with this for months now, Judge, and every time, we tried to make it in a direct, very sterile way, and then they dodged it, and they filed this prosecutorial misconduct when any fool can read what happened to these things. And now when we're about to prove things, which is what the jury trial is about, now they want you to just tell them something. Well, I'd rather that we're not asking for a stipulation. We're not asking for an instruction. We're asking to explain the factual history of what happened to these samples. And whatever legal instruction you give at a later point, I'm sure will comport with the process or the due process requirements that we can't comment on the defendant not testifying or them not presenting any evidence. But this is the factual history, the chain of custody of these things. And we've tried in many ways to resolve this. And now when it comes time through the logical witness to begin the proof process, now they want you to just tell them something that's just not quite true, consistent with the factual history of these things. I think we should just prove it, Your Honor.
All right, thank you, counsel. I'll contemplate that. Mr. Goldberg, let me know when you're about to launch into that. We'll take a break, and I need to look at two cases before I rule on this.
Thank you.
All right, let's proceed.
One other quick issue. Mr. Goldberg showed us some papers, some handwritten lab notes this morning that we have never seen before. He indicated that he thought they'd been turned over. Mr. Scheck and Mr. Neufeld and I have never seen them. We don't yet have copies of them. I would ask that we be provided with copies and that he not elicit any testimony concerning these documents until we've had a chance to explore them and find out why we didn't get them in a timely fashion.
What are these things, Mr. Goldberg?
Your Honor, these are not lab notes. This is an item that was generated on 6/29/94, which are the handwritten copies of the inventory that was done, that was the subject of the Griffin hearing, and that was subsequently generated in a typewritten form. Counsel says that he does not have it in a handwritten form, but I believe that the handwritten copy of this was introduced at the Griffin hearing itself as an exhibit, as Exhibit K to that hearing. But he is correct. It does not have L numbers or D numbers. But if they went through the Griffin hearing materials, they'd find that this is, as I said, Exhibit K.
All right, Mr. Goldberg, are you going to get to any information on that at this point for our next recess?
I could, and as I said, it's identical to, well, I'll probably get to it sometime around when we address the photographs that are the subject of the court's other pending.
All right, is there an item K from the August hearing? You pull that out, Mr. Jarbison.
But at any rate, it should be identical to the typewritten one that was generated from it.
Was that during Mr. Matheson's testimony?
No, I believe that was during Ms. Kessler's testimony.
How many pages are these handwritten notes, Mr. Goldberg? Just the 11 pages?
That's correct, Your Honor. By Mr. Scheck.
All right, item K in the transcript in the list of exhibits at page 6, transcript of August the 23rd indicates item K
He was very strong, Richard. You're right.
are handwritten notes, 11 pages dated June 29, 1994. And the testimony was that these were then converted into the computer-generated printout. And they were, as you indicate, marked by Mr. Scheck for the purpose of that hearing. Later.
Well, I wasn't aware of that. I know that they're not in the lab book. These are handwritten notes that we were under the impression we were given all of the handwritten notes prepared by people at SID. I don't believe those are in any of the discovery documents, whether they were provided at the time of that hearing or whether Mr. Scheck got a copy. I'm just not sure. But I know there is a typed document that
Right.
presumably mirrors that.
Well, it appears that Mr. Scheck had them for the use of the Griffin hearing. So the argument that you haven't seen these before, I'll have the staff make you a photocopy of what Mr. Goldberg has. Do you have any additional copies, Mr. Goldberg? Mr. Goldberg, do you have any additional copies? All right, would you give that to Mr. Byrne for me, please? Mr. Byrne, would you make some photocopies of that? All right, let me know before you get to that particular document, and we'll get a copy for council. All right, let's proceed.
Your Honor, also, we had a number of foundational objections right before lunch that
That's correct.
we need to resolve.
All right, what's the nature of your objection? Your
Yeah,
foundational objection,
Mr. Neufeld has prepared the brief on this. Asked that he argue that if possible.
Well, you're the one presenting the witness, counsel.
Well, we strenuously object to have Mr. Matheson testify about the results of any testing conducted on Mr. Simpson's reference sample without a proper foundation being established, and that foundation being testimony by the nurse who drew it, the manner in which it was drawn, how it was preserved, how it was logged in, how it was packaged, and how it got to the point where he performed testing on it. The foundational question, as the court is aware, we're raising serious questions about foundation, chain of custody, packaging, collection.
Do you have any argument that's not included in Mr. Neufeld's written argument?
No.
All right, Mr. Goldberg.
Well, Your Honor, on page 19367 of the transcript, it's volume 110 of Detective Van Adder's testimony. He did testify to seeing the item drawn, to the defendant being in the jail dispensary and blood sample having been drawn, and that he then took that blood sample and dropped it off to Mr. Fung at the Rockingham location. Actually, the chain of custody on the blood sample has been more thoroughly explored in this case prior to Mr. Matheson's testimony than any other exhibit that I can recollect in any of the previous trials that I've been involved in. I mean, we've gone into this for hours and hours and hours, and we have testimony leading from the time that it came out of the defendant's arm to the time that it was packaged up in the gray analyzed evidence envelope and booked. That's the first argument. So just simply factually, the defense is wrong. The second argument is on order of proof. The court has complete discretion with respect to the order of proof and how witnesses are going to be called. If we were to require a chain of custody to be done on every item prior to the witness testifying to it, then we would not be able to get into evidence of the fingernail scrapings because we haven't heard from the coroner yet, or the clothes that came from the coroner on which the testing was done, which we clearly can do. And we would not be able to present evidence on the victim's reference vials, which came from the coroner. A lot of these things have to be tied up later. And we also have a situation here where items of evidence were exchanged back and forth between Cellmark and the Department of Justice. So how would you do that? I mean, one of those organizations has to testify first. So if Cellmark testifies first, they're going to be testifying to items, some of which...
Let's look at the item that we're talking about here today.
Well, the point is, Your Honor, is that there are dozens of items, the chain of custody of which is going to be proved through other witnesses, whether they're coroner's witnesses, whether they're DOJ witnesses, whether they're Cellmark witnesses, or whether they're other SID witnesses. We also have...
I'm not interested in that issue or that argument. I'm just interested in this blood vial, this particular situation.
And that's
right,
what I'm trying
guys.
to address is order of
I'll be
proof,
back soon.
which is contained in
Behave.
Penal Code Section 320, which says that except as otherwise provided by law, the court in its discretion shall regulate the order of proof. And we just know that the case law is replete with instances where courts have virtually absolute discretion in doing this. This case has to be presented or should be presented in some kind of orderly way. And we could call a lot of witnesses twice, once for chain of custody and then for their respective tests. It doesn't make any sense to do it that way. So certain aspects of the chain of custody will have to wait until later to be proved. So that's the second argument. The third argument is a business records argument. We have the case of People versus Aguilar, which I cited which was cited in the points and authorities that we prepared, and stands for the proposition that you can prove the chain of custody of narcotics evidence of a police officer that was deceased by his notations on the evidence package. as the court is familiar, evidence packages typically contain a chain of custody statement where the police officer fills out what he did with the chain of custody of the item. And that was held to come in under as both an official and business record. In this particular case, Mr. Paradas filled out that same type of chain of custody statement, which is in the pictures, the photographs of the analyzed evidence envelope.
Has Mr. Paradas been
What?
withdrawn? Has Mr. Paradas been withdrawn from the People's Witness List?
No,
And he will be testifying.
he may be testifying at some point.
Isn't that something I need to know now?
Well, the issue is one of chain of custody. And the issue is one of foundation. And the court asks, is that something the court needs to know now? We believe that
No,
that issue.
your argument is order of proof. You're telling me that you don't need to call this guy right now.
Right, and if the court concludes that we do need to call him at some point, we absolutely will, obviously. We're going to do whatever needs to be done in order to establish a chain of custody of these items.
So it implied in your order of proof argument is that that person will be coming sometime during the case in chief.
Or maybe coming at a later time if the court so orders, or if
Later
the court
than-
so finds.
Later than the case in chief.
Well, no, later in the case in chief.
Okay, all right.
But the first argument, as I said, Your Honor, is that we don't need to call him at all legally because we've established it through an eyewitness, Detective Van Adder. And the third argument is that we don't need to do it because we have the business records and we have a case that's on point that says that chain of custody statement on the envelope does qualify as an official record.
All right, Mr. Blazer, any brief response?
This is not a chain of custody argument. This is a foundation argument. We would ask the court to use its discretion, which we accept the court has, to say this is important. This person should be on first to establish the foundation before Mr. Matheson testifies about test results. Mr. Paradas was on their witness list. He was going to be called before Mr. Matheson until people changed their mind a week or so ago. We would ask that that be done first, and that the court not allow the prosecution to suspend this witness's testimony or Mr. Paradas' testimony for some indefinite time in the future.
Thank you, counsel. I agree that I believe also that the court has not unbridled, but certainly wide discretion as far as the order of proof is concerned. I will allow Mr. Matheson to testify to these matters subject to a motion to strike if Mr. Paradas is not called as a witness. All right, let's proceed.
Just for the record, is the court rejecting the people's argument about Detective Van Adder being an eyewitness to the drawing and transmittal of the blood?
I'm saying,
There's
no,
no
I'm not
doubt.
rejecting that as testimony, but there are other things that perhaps are missing in the foundation. Medically approved method, use of a particular file, who knows? I haven't examined Detective Van Adder's testimony from months ago.
Yeah, I just want to mention the court was ruling on that issue.
All right, let's have the jury, please. All right, good afternoon, ladies and gentlemen. All right, the record should reflect that Mr. Gregory Matheson is again on the witness stand undergoing direct examination by Mr. Goldberg. Good afternoon, Mr. Matheson.
Good afternoon.
You're reminded, sir, you are still under oath, and Mr. Goldberg, you may continue with your direct examination.
Thank you. We were talking about EDTA vials and not refrigerating them. Can you give a simple explanation as to what happens if a vial were not refrigerated for a lengthy period of time and the material degraded? What happens?
Isn't that question kind of vague, lengthy period of time?
Okay, well, let's say that it's not refrigerated for a long enough period of time so that the material degrades, however long that is. What happens?
Well, as far as a analogy or an explanation, it's similar to the degradation of any form of biological evidence or sample. I like to use as an example when it comes to field evidence, which could then, I suppose, be carried through over to a blood vial that was improperly stored. It's just like having a piece of meat or any other sort of biological entity. If you leave it sitting out on your counter, eventually it's going to rot to the point where it's going to be unusable or go bad. in the case of biological evidence or blood in a blood vial, eventually under improper storage conditions, the components within it are going to rot and break down and become unusable for forensic purposes.
Okay, when you say unusable, what do you mean?
That when we use those items in our testing, we will get no results.
But does the degradation that takes place or can take place in a blood vial, is it going to change the nature of the blood so that it appears to be someone else's?
Well, as a rule, it won't change. It'll just go to the point where you cannot get any sort of result. There is one exception to that, but as a rule, it will not.
Okay. And when you say one exception, I don't want to go into this in detail right now, but are you talking about one particular genetic marker?
Yes.
Okay. Now, excuse me. When you ship biological material out to an outside laboratory, is it shipped in a frozen condition?
No, not at this time. We place them into like a Federal Express or something like that, overnight pack, and ship it.
So there may be as much as a 24-hour period of time that it is not frozen as it's being transmitted.
That's correct.
And what is the effect of that?
It doesn't appear to have any. We originally, when we started submitting evidence for DNA analysis, used to package them in cold packs and created very large containers. And we got away from that and have not noticed any change in the results or the quantity of positive typing results that we've obtained.
And were you in fact able to perform conventional testing to determine the genetic markers on the reference sample, item 17 in this case?
Yes, I was.
Now, going back to continuing on with our evidence collection questions, when evidence is being collected at a crime scene, do you use clean instruments or sterile instruments?
They're clean, not sterile.
And is it sufficient to use clean instruments?
Yes, it is.
What's the distinction between clean and sterile?
Well, in the case of a sterile instrument or something, it's been autoclaved at a high temperature to remove absolutely every little bit of any form of biological material, or to render it useless in essence. They're sterile. It'd be like in surgical instruments and that type of thing. Clean is a matter of wiping them down using what we call a chem wipe, which is a kind of a scientific tissue, and a little bit of water or something, wiping off all the residue that's on it.
And is it accepted forensic practice to use clean instruments as opposed to sterile in the field when you're collecting biological samples?
Yes, it is.
Have you ever noticed any problems with that in the years that you've been in serology?
Sustained phrase question.
Have any problems been encountered as a result of using clean instruments in terms of contaminating samples?
Sustained phrase question.
Sir, when you use clean instruments, do you use the clean instruments to pick up the control and the swatch?
Yes.
And if there were a problem in using a clean instrument, would you expect that to show up somewhere in the testing?
Well, that's one of the reasons you take a control, is you're handling it in the same way as you are the evidentiary blood stain or whatever biological stain it happens to be. And if there was a problem in using clean rather than sterile, I would expect to see an ongoing problem with results showing up in our controls.
And have you noticed any such problem in the years that you've been in serology?
No.
What about changing gloves between the collection of biological specimens? Is that something that's necessary?
Not between everyone, just as a matter of course. I would expect somebody to change them if the gloves got particularly dirty or bloody from handling something, but just to say you have to change it between every item, that's not necessary.
Why?
Well, for one thing, you want to be using techniques that limit as much handling as possible with that item. Whether you're wearing gloves or not wearing gloves doesn't mean that you're going to be grabbing the item in inappropriate ways. You are trying to limit the amount of contact that you have with it. And as a rule, even with gloves on, your gloves never come in contact, particularly when you're talking about swatching blood stains or something like that, come in direct contact with the evidence item itself. So there would be no need to change your gloves in between.
Would it be possible to collect stains from a crime scene? Well, of course it would be possible, but could you collect stains from a crime scene without using gloves?
If you use good practice and not handle the evidence or not allow it to come in contact with your skin, sure, you could do it without gloves.
Would there be some health concerns in doing it that way?
That's true. I mean, that's one of the major reasons for wearing gloves and a lot of this protective equipment, is to protect the operator from the evidence as opposed to the other way around.
And if there were some problem at the crime scene where a person were collecting the evidence by touching the swatches with their hands instead of using tweezers, could the controls detect whether that had caused contamination?
if somebody chose to collect bloodstains by just using their fingers and then chose to use the exact same technique on the controls, that's one of the reasons for the control, like I mentioned before. If the technique is the same and you're transferring information or biological material from your own hands onto the evidence, you also then be transferring it onto the control, and I would expect the control to show that.
Okay. And let's say that you decided to use this technique, if you want to call it that, of just collecting the evidence with your hands as opposed to tweezers. Would that be an improper technique in your judgment?
Yes, it would be improper.
But would that improper technique cause the blood at a crime scene to somehow change into someone else's blood?
No, it's not going to change in any way. You may be adding additional information to it from your own biological material, but it wouldn't change what's already there.
And similarly, on the tweezers example, where we were talking about clean versus sterile, is there any way that using clean tweezers could change the biological information in the blood?
No.
And why is that?
Well, it's actually, we've touched on it off and on before, in that the only thing that's going to happen to a blood stain is through degradation. You're going to get no result as opposed to a changing of the type, or the addition, if the tweezers happen to be not as clean as you think, or have become contaminated in some way, you're going to have the addition of information to it rather than the changing of the existing type that's there.
And if you were collecting a series of stains using one of these improper techniques, or the improper technique of not changing gloves and using the glove itself to collect the stain as opposed to the instrument, would you expect it to somehow change the biological information in all of the stains consistently?
I'm not sure.
In other words, if you had 5 stains at a crime scene, would you expect the same changes to occur to all 5 stains?
If your gloves are dirty to the point where you are adding information to it and continuously doing this, then you're going to see, if I understand the question right, you will then see this additional or contaminant showing up in all of the samples. Potentially, if you start off with a contaminant from your first sample and don't recontaminate it, so to speak, eventually you would use it up, and I guess your last sample may not show as much, but I don't know.
Okay. When you say contaminant, what do you mean by that?
Well, contaminant is really anything that doesn't belong in its original situation. Example being a blood stain that is left at the scene of a crime is a contaminant to that scene. Anything that's added to that blood after the fact is a contaminant to that blood. It's something that doesn't belong.
So is there any more precise definition of contaminant that's used in the forensic science community to discuss when information is being added to a stain or to a piece of biological evidence that didn't originate in that evidence?
As far as, a contaminant is what I described before. I'm not aware of any particular definitions when it comes to biological evidence. It's just the addition of something that didn't belong there to begin with.
So it's a fairly ambiguous term, somewhat ambiguous.
I don't know if it's ambiguous so much as there is not a forensic definition of contamination versus, any other definition of contamination.
So using the definition that you gave, could you consider the blood drops themselves of a suspect deposited at a crime scene as being a contaminant?
It would be a contaminant to that location, right?
Now, as to the collection techniques that were used in this particular case, did you view a videotape of Andrea Mazzola demonstrating the collection process of a stain?
Yes, I did.
And did you see any problems that arose in the collection of the mock items in that case?
Objection made.
That could affect the collection?
I didn't see anything in the way that she handled the swatches, the tweezers, that type of thing that would affect the ultimate integrity of the evidence.
Well, I want to show you that video, but apparently they don't have it right here. Let me ask you a few more questions about collecting biological evidence. Is biological evidence, can it be deposited both through direct and indirect forms?
Yes.
And what is the distinction?
So if I understand the question, a direct deposit would be if I cut myself and then proceed to drip it, excuse me, at a scene or a location. A indirect, is that the other?
Yeah.
I believe an indirect or potentially secondary transfer of that evidence or stain would be if I was to drip some of my blood onto a piece of cloth or something like that, then that piece of cloth came in contact with something else that's transferring it a second time.
And do you, as a serologist, type both kinds of evidence that was deposited as a result of a direct transfer as opposed to indirect transfer?
Yes.
If you had a situation where a suspect leaving a crime scene stepped in a pool of blood and then went into a vehicle and transferred that blood into the vehicle, would that be direct transfer or indirect transfer?
By the definition given earlier, I'd call it indirect.
And does your laboratory type that kind of a stain?
Yes.
Now, if you view the suspect's action as a collection procedure, in terms of collecting the evidence in the pool of blood from the crime scene, would that be a forensically accepted collection technique?
No, it would not be acceptable to collect a blood stain on the bottom of a shoe.
So why is it that in cases where evidence is collected on the bottom of a shoe, you can still go ahead and test it?
Well, the blood is still the blood. I mean, it's a situation where regardless of whether it was dropped directly from a person or transferred from one to another, it still has some significance. You're aware of the fact that it was not dripped there, particularly when you see a smear or something along that line, but there's still information that can be derived from that sample as far as the genetic types that are present.
Does the fact that the evidence is collected on the bottom of a shoe change the genetic markers in the evidence?
No, it doesn't.
So can it change the blood from the victim's blood into someone else's blood?
No, it doesn't.
Let me give you another hypothetical situation. Let's say you had a situation at a crime scene where a cat walked into the crime scene and collected some of the blood by stepping in it with its paw. Could you collect the evidence off the cat's paw and still test that?
Yes, we could. I'd want a control collected from a clean paw to see if the cat contributed anything to it, but you could test it.
Okay. So if evidence at a crime scene could be collected by a house cat, do you think that the criminalists, Andrea Mazzola and Dennis Fung, were qualified to collect the evidence in this case? Is silly an objection? I didn't know it.
Why don't you rephrase the question?
That's okay. I'll withdraw that question. I'd like to show you the video that's been marked as 1117 for identification.
Noting that we have seen this several times, Mr. Goldberg.
I know, Your Honor, but I'm not going to stop it. We'll just run it all the way through. Mr. Matheson, did you notice that she did touch the ground with her right hand, gloved hand?
Yes, I did.
Does that present a problem?
No.
Why not?
I would be concerned if her hand touched the ground and then she took with a glove on and then she took her gloved finger or something and smeared it around in the blood stain. But with the process of using the forceps or the tweezers, the glove never comes in contact with the evidence itself.
And now she is laying down the control by card number 5.
Yes.
Assuming, sir, that the water in this control eventually migrated over to the stain, would that present a problem?
No.
Why?
Well, the water is the exact same water that is being used to dampen the control swatch and dampen eventually the swatch that you use to collect the blood stain. And the fact that, as you notice, she takes her control very close to the stain, so the substrate or the concrete that it's sitting on is going to be basically the same under the stain as is under the control. The worst it's going to do is maybe slightly dilute the blood stain, and it may actually start moistening it up, making it easier to collect. No, that's not a problem.
Would it change the result in any way, the migration of the water?
No, it would not.
Now, if you look closely, it appears that some swatches fell out of the cap.
Yes.
Does that present a problem?
No.
Why not?
Well, I don't believe that at any point does she take any of those swatches and use them to collect any of the sample. They're left sitting down there. Actually, they're brushed aside at some point. You're going to drop them occasionally. I mean, that's just the nature. There's a lot of swatches in that vial. You shake them out. A few are going to fall on the ground. I suppose it could be a minor littering problem if they didn't pick them up when they were done. But as far as the evidence goes, no, it doesn't affect it.
Now she's collecting the stain from the item that was labeled number 5 in this demonstration.
That's correct.
Now she appears to be putting stain 5 into one of the plastic bags.
Yes.
Are those the kinds of plastic bags that you use at the crime lab when you're collecting stains?
Yes, it is.
Okay, now we've gotten up to the point where she's already collected the control and the stain from card number 5.
Yes.
Have you seen anything up to this point that would cause the results that you obtained to change into someone else's blood?
No, I have not.
Or that would present a problem in terms of the analysis of the blood?
No.
Has her collection procedure been in accordance with the way that you're training people at the crime laboratory to collect evidence?
Yes, it is.
Now, Mr. Matheson, she appears to be working on the second stain at this time.
That's correct.
And is there any problem with not changing tweezers or gloves between stain 5 and stain 6?
No, there isn't.
Why is that?
Well, as I mentioned earlier about the gloves are not coming into direct contact with the evidence. That's not a problem. If you'll notice, she has cleaned the tweezers several times between each of the steps using dampening, that chem wipe that I mentioned before, the tissue with what appears to be water, and then wiping the tips of the tweezers or forceps off very carefully.
And is this collected in such a way so that the swatch itself does not come into contact with the gloved hands of the criminalist?
That's correct.
Now, she appears to just have written something on the plastic bag. What do you write on the plastic bag when you're collecting a stain?
Actually, it depends. Obviously, within one envelope, eventually, when you're collecting a stain off of something like concrete or off of a surface, you're going to end up with a coin envelope or the manila envelope containing 2 separate plastic bags with the samples in it. Usually, I like to mark either the item number on it, or if I don't do that, at least a C on the control plastic bag. However, there have been times where it was very obvious which was my control and which was the stain. The stain was blood colored and very heavy, and the control was either relatively clean or kind of a grayish, so it didn't matter whether I marked them or not because it was obvious which was which.
Now, just before this, she dropped a few more swatches. Again, did that present any problem in terms of the collection of stain 6?
No.
She's just placed the swatch of number 6, the blood swatch, into the envelope.
That's correct.
Have you seen any problems in the collection procedure to this point?
No problems with the collection procedure. The only thing that I would, if this was a training issue or something for us, or we were looking at it, I would suggest that maybe it'd be worth going back with another swatch on the evidence sample and collecting up a little bit more blood. But as far as the collection technique itself, it's just fine.
So if it were a real stain, you'd want to use more swatches on both 5 and 6?
Yes, yeah, to get as much of the sample as possible.
Right, thank you. And why is it that you use multiple swatches on a single stain?
Well, we teach the people to select a swatch size that's appropriate for a stain. If you have an extremely small drip, you don't want to use a real large swatch because then the blood stain gets kind of diluted out over the swatch itself. If you have a large stain, theoretically she could have gone with a larger swatch on that than she had in, that she'd chosen, but odds are that was among the largest one that was in that vial. So instead of going to a much larger one that isn't available, just use multiple smaller ones.
Is that typical that multiple swatches are used in collecting a stain?
Yes.
And when multiple swatches are used, is the criminalist supposed to notate how many swatches they used at the crime scene?
There's no rule to that effect, no.
Okay. Why is it that you don't have a rule in place that you should notate exactly how many swatches you used on a particular stain?
Because we've never found it to be important to know exactly how much is there. You've got your photograph of the stain, the evidence is a stain that's down there, and the swatches are immediate to collect it on.
Okay. Now, let's say that someone at a crime scene, a police officer who didn't know how to collect a stain, had used a completely improper technique, such as taking out a handkerchief and spitting on it to dampen it, and then collected the stain using that technique, submitted it to you for analysis. Would it still be possible to type even in that extreme situation?
Yes, you could still do an analysis on that stain.
Wouldn't the police officer have arguably introduced some contaminant that could be tested as a result of spitting in the handkerchief?
Definitely, it'd be an improper way to do it, but it could still be typed.
So what would you do in order to resolve that problem?
Well, in a situation like that, if that was the only evidence that we had available to us, we would be able to run the particular stain. I would want to run a control area from the Kleenex and also get some saliva from the particular officer.
Well, what could you do if you had some saliva from the particular officer in order to sort out what the genetic markers were in the person who deposited the stain?
Well, if you had saliva from the...
Oh my God. Who else is dying to see what the defense says to this guy? Who else? Who else is dying to see how they're going to respond to this? My goodness. Finally, we have someone saying what we've been screaming the whole time out loud.
person, and that particular
I can't
marker
wait.
appeared in the saliva, you'd know the type of the individual who spit onto the handkerchief. How that affects your ultimate interpretation will depend an awful lot on the types that were found in the stain and the types of the person. It obviously is going to lessen some of the value of that stain, but there's still information there.
Could you still determine whether the genetic markers of the stain were consistent with the suspect, even though this collection procedure had been used?
It's possible. It would depend on the types of the people and how the results came out, but it's possible.
But would the spitting in it actually cause the genetic markers of the suspect in the stain of blood to somehow change, or would they still be there?
No, they'd still be there. You'd just be introducing additional information to it in the form of the types of the person with the saliva.
And does the Los Angeles Police Department serology section, in fact, type cases routinely where there are mixtures, where there's more than one donor to a particular stain or a particular item of biological evidence?
Yes, every sexual assault case we do, by nature, if there's semen present on a sexual assault kit that's collected from a victim, you are dealing with a mixture of body fluids.
And in those kinds of cases, are you still able to test that mixture to determine whether it contains genetic markers that are consistent with the suspect?
We're able to do the tests. However, because of the fact that it's a mixture, our chances of giving a very definitive answer as to what's coming from the victim and what's coming from the suspect is less than when you're dealing with just a blood stain. But there is still information to be derived.
And are there still instances where you're able to find that there are certain markers that are consistent with the suspect, but inconsistent with the victim?
Yes, we do on occasion include suspects based on what we find that's foreign to the victim and could have come from that suspect.
So in these sexual assault type cases, do you usually get evidence of a mixture from two people?
Many times, yes.
And then if you get a mixture from two people, what do you have to do in order to figure out which part of the mixture belongs to the suspect and which part of the mixture belongs to the victim?
close. I think this is just a, let's wind this up.
Okay, I'll withdraw that question then.
All right.
Now, sir, if bloodstains can be collected by people who are not criminalists, why does the Los Angeles Police Department use criminalists or try to use criminalists in collecting these stains?
Well, a criminalist is not just performing the function of collecting a stain. What we have in our laboratory is what's called a generalist philosophy, where we try and teach a criminalist about all aspects of forensic science. They may specialize in one particular area like toxicology or firearms or serology, but through experience and involvement with other criminalists, we try and get them to have a sense of the whole concept of forensics. So by having somebody out there at the scene that works in the laboratory and is acquainted with all the different possibilities that exist when it comes to analyzing physical evidence, it just enhances the possibility of collecting the best possible evidence.
Now, at crime scenes, does the police department use both criminalist 1s and criminalist 2s and 3s for the purposes of investigating a crime scene?
We send all those out. As a matter of fact, we send out at times supervisors, and lab directors go also.
And when you send a criminalist 1 to a crime scene, are they paired with someone?
Yes, as long as they're a criminalist 1, which is for the first 18 months of their employment, they will always go with either a crim 2 or a crim 3, preferably a criminalist 3.
What is the purpose of sending the criminalist 1 with the criminalist 3?
Well, it's all part of the learning process. We're always learning new things when we're out there, and for that first 18 months or so, we try and get them out to as many scenes as possible, exposed to a lot of different conditions and types of scenes, to the variety of techniques that different criminalists have as they go through their career, and allow them to then establish their own mindset or experience to collecting evidence, so that when time comes that they are doing one on their own or potentially training somebody else, they have all the experience that is afforded to them.
So what is it that the criminalist 1 is learning in this first 18 months? Are they learning the physical mechanics of how to pick up evidence? Or are they learning the mental processes that a criminalist goes through?
Well, they're learning both. It depends on the background of the individual. If we have somebody start in the laboratory that has some sort of forensic background or experience, odds are they've picked up the mechanics. We're going to confirm that the first couple of times they go out. But they're not difficult techniques. After that, it's a matter of just getting exposed to an awful lot of different ways of looking at a scene, the way of thinking about how to go about processing it, and just constantly picking up experience. I still go on crime scenes myself where I learn something from somebody else on either a better way to do it or thinking about something that I hadn't thought of.
So after the criminalist 1 already knows the mechanical techniques of how to pick up, say, biological evidence and shoe prints, lifts, and the like, why is it that you just don't set them loose and let them go to the crime scenes themselves for the remainder of their probationary period?
Well, it's kind of like we were talking about before. We want them to get as much experience as possible when it comes to how to evaluate a scene. We can teach anybody to go out there and do some of the mechanics, but there's this buffer, this 18 months from the time somebody starts until they are considered crime scene ready, or that's a target that we shoot for, where you are learning. You're just being exposed to new situations, new things, taking in as much information as you can about the mindset of investigating a crime scene.
When you say mindset of investigating a crime scene, what are you talking about?
The different philosophies of what type of evidence exists, how to approach the evidence, how to think through and use selectivity that we were talking about earlier, as far as trying to find the evidence that's most important to the questions at hand.
Which part of being a criminalist, in your experience, in terms of investigating crime scenes, is more difficult? The mechanical part of how to pick up a piece of evidence, or the mental component of what type of evidence to pick up?
Well, it's definitely the mental component, because like I just said, I've been doing it for almost 17 years and I'm still learning stuff out there. I go out to a crime scene and almost always get a little more insight in how to handle a scene.
Now, when the criminalist is at the crime scene, do they have an obligation to investigate whether there have been any alterations in the crime scene?
Their primary function there is the collection of the evidence. The information as to whether or not something has been altered is really not very deep. We sometimes record if like a rescue unit had been in prior and dealt with the scene or something along that line. But normally we have our hands pretty full just looking for the evidence and collecting it, documenting and collecting it, so that when it comes to searching down every little bit of information as to whether something was touched or something was moved. No, that's not our duty.
Here we can see Defense 1081. This is is this a portion of the crime scene identification checklist form?
Yes, it is.
And here there's a little section that says, has the scene been altered? If so, by whom and how? How is that portion of the checklist supposed to be used?
I have always used it and taught other people to use it, that it is for gross information. Like I just mentioned, if the rescue unit had arrived prior to our being there, because they many times leave things behind that we don't want to collect as evidence if it was brought in after the fact. Such things as if an area was washed down prior to our arrival, which does happen sometimes. More of that gross type of information.
And is the criminalist ever supposed to do formal witness interviews of people to determine whether the scene's been altered so that this area can be filled out?
No, they're not.
Now, what about crime scene security? What does the criminalist have to do with providing for security or seeing that security is provided for at the crime scene?
Our major concern when it comes to crime scene security is just like wearing gloves or other protective equipment. I want to make sure that the scene is secure for my own safety and protection. I'm going to arrive. I'm going to make sure that there are officers at the scene or detectives or somebody else that's present. The fact that we're a civilian, that's important. As far as making sure that there is tape up or officers present to keep out people that may alter the scene, it's not our responsibility to do that. There have been instances where I have been working a scene and somebody has walked through the tape and is like heading into the crime scene or something, and I will see it before the officer and I'll point it out and say, we need to get this person out of here. But that is not my prime focus. My prime focus is in on the evidence and the evidence collection.
Now, at a crime scene, is it typical that photographs are taken both before the body is removed and then after the body is removed?
Normally, yes.
Why is that done?
Well, to properly process a crime scene, you want the photographer in there as early as possible before, obviously there are certain things that must occur. If you have a victim, there's going to be an initial responding officer or somebody going in to clear the scene or whatever. That's prior to our arrival. But as far as processing a scene, we want a photographer to go in even before the criminalist to document everything exactly how it is before we get in there and start, moving things around or taking measurements or walking through the scene. We then have after the overalls or the general shots are taken, have our individual evidence items photographed, and that could be happening either before or after the body's present.
How often is it that a piece of evidence is moved between the before photographs and the after photographs?
It happens occasionally.
And in what context does it happen?
Well, there are times where a particular piece of evidence may have some information on it that is needed at the moment, a piece of paper with some writing on it, an item that we want checked for blood or something like that. If the photographer isn't available, there will be times, knowing that the overalls were taken, knowing that the general scene has been placed with photography, we may pick that item up, run a presumptive test on it, or like I said, look at a piece of paper for some writing or something, and then try and place it back for the close-up picture just prior to collection. Sometimes it's not going to be placed back in the exact same location. And it does occasionally happen too that during the course of your processing, you may accidentally bump something or you may kick it. You try real hard to watch where you're stepping, but sometimes you do get focused on other things that you're doing and evidence does get moved. That's one reason why it's so important to get the photographer in there first, because those are the pictures that place the evidence items where they belong or where they were originally. And then the subsequent photography is mainly to identify that item, to give you good close-up pictures of it, so at a later time you can compare it to what you have in front of you.
So part of the reason for taking the before photographs is so that if an item of evidence is moved, you can determine exactly where it was initially?
That's correct.
Now, in the testimony that you heard, did you hear some evidence as to a phenolphthalein test being performed on the glove at the Rockingham location?
Yes, I did.
And is that acceptable from a forensic standpoint and from a crime scene investigation standpoint?
You mean as far as running a presumptive test in the field?
Yes.
It is, however, it depends on the particular item. If there was a evidence item or a extremely small spot of blood or a extremely small stain that you thought might be blood, and that by running your presumptive test was going to consume either all or a major portion of that stain, I would not want the criminalist to run it. I wouldn't run it myself. I would just collect it, where you can then do that same test in the laboratory, but on a much more micro scale. However, many times in the field, we do test objects and bloodstains for the presence of blood. And if you have a large stain, you can see a area that's discolored. In this case, the glove that was showing, because it was a black glove, you didn't necessarily see what was obviously red blood on it.
We're going beyond the original question. Proceed.
Sir, would you have done a phenolphthalein test? Had you been asked by one of the officers there to perform one in the field?
Sustain.
In this particular case, based upon your understanding of the evidence, would doing a phenolphthalein test harm or somehow interfere with the ability to do future testing on that glove?
Overruled. I take it we're talking about the,
Phenolphthalein.
which glove?
Talk about the Rockingham glove.
The only thing it would do would be to remove a small amount of the blood that was present. It would not alter the type in any.
Do the criminalists comply with reasonable requests that are asked of them at the officers at the scene?
Yes, they do.
Overruled.
And would it be reasonable, in your estimation, under the facts and circumstances of this case as you know them, to have requested a criminalist to do a phenolphthalein test on the Rockingham glove?
It's vague. Or, reasonable in a scientific sense. Is that what we're interested in? Do
In a scientific sense, from a forensic science standpoint.
you understand the question?
Yes. Yes, I believe it would be reasonable.
Generally speaking, at a crime scene, how do criminalists interact with the detective?
It's vague.
What is the relationship in terms of the collection of the evidence between the detective and the criminalist?
As far as the collection of the evidence, that's the domain of the criminalist. Normally, when we arrive, the detectives have already been there. They do the walkthrough with us. We interact with them, get their opinion as to what they have found, what evidence they are interested in collecting, and we note those items either mentally or on paper, depending on the person, and do a search ourselves. So we try and interact with them, working as a team regarding that aspect of the crime, and that is the scene and the collection of physical evidence.
Now, did you also hear some testimony about a blanket that was at one point brought out for the purposes of covering Nicole Brown?
Yes, I did.
And what kind of problem would that blanket present, if any, in terms of the biological evidence at the Bundy location?
Sustain.
Sir, if a blanket were brought out into a crime scene,
Let's see if we can figure it out.
are you familiar with the layout of the crime scene?
Yes, I am.
Into the area where the body of Nicole Brown had been laying for the purposes of covering her, and then the blanket remained there after she was removed. Would that present a problem in terms of the biological
I
evidence
can't remember his
that was
name.
collected from the Bundy
It looks like
location?
that guy, maybe. Maybe.
I'll sustain the vague. The question's
Yep.
unintelligible.
He's still there.
Would that
It's
present a
this guy.
problem in terms of contaminating any of the biological evidence?
It would depend on what the blanket had on it to begin with. If the blanket had large quantities of blood or had blood on it, and then that blood came into contact with something that we eventually ended up collecting, then we would have contamination occurring at that point. If it was a clean blanket, as far as the biological evidence is concerned, and it does not come in contact with the collected evidence item, it should have no effect.
Okay, well, let's assume hypothetically that the blanket had some saliva from the defendant in this case on it that had dried and did not come into contact with the stains that were collected along the trail. Would the blanket present a problem in terms of contaminating those stains?
No, it would not.
What would you have to do in order for the blanket to contaminate the stains?
The biological stain on the blanket would have to somehow come into direct contact with the biological sample that was being collected. And even then, unless there was some moisture present, you would not have significant transfer. If one or both of them was damp and they came in direct contact with each other, then that would be a problem. You would have potential transfer of one body fluid into the other, thus contaminating it. But beyond that, it should not have a problem.
So even in the case of direct contact, you're saying that the biological material on the blanket would probably have to be wet in order for there to be a transfer?
For there to be significant transfer yet, I would not like to see that happen, and I would be concerned about any sample that happened to. But the transfer would be significantly less than if one or both were damp.
Okay. And if it did not come into direct contact, then you're saying that if we were to assume that the only biological evidence were the hypothetical dried saliva, it would not present a problem?
That's correct.
Now, does DNA tend to fly around in the air at a crime scene and deposit itself wherever it happens to land?
Just randomly floating around a scene?
Yeah.
No, I wouldn't expect that to happen.
And if you have a crime scene where biological evidence has been deposited by a suspect who was bleeding on a trail of stains, do you expect biological evidence from one stain to migrate to the other stain? If we assume that these are discrete drops.
I don't see any way that if they're discrete drops, how you'd get one transferring to the other unless there was something carrying it from one to the other.
But it doesn't just like hopscotch from one stain to another in some fashion.
No.
Now, did you also hear some evidence to the effect that the glove from the Rockingham location was in a brown paper bag and was brought into the caged off area where the body of Ron Goldman was located?
Yes, I have.
And what problem, if any, does that present in terms of contaminating the crime scene?
Well, merely bringing an item in a paper bag should have no effect whatsoever on the evidence at that location.
What about on the glove?
I mean, evidence from the scene getting onto the glove?
Yes.
The same thing. It's inside of a paper bag. It's not coming in direct contact with any of the evidence at the scene. I don't see where it would be a problem.
Now, there was also some evidence of some socks being recovered at the Rockingham location. Are you generally familiar with that?
Yes, I am.
And you took a look at those socks yourself.
That's correct, a couple times.
Now, would you expect there to have been flaking from blood encrusted on those socks at the time that they were taken off based upon what you saw?
Sustained.
Did you do an analysis on the socks yourself?
Yes, I did.
All right. And were you familiar with the extent to which blood was visible on the socks from the naked eye?
Yes, that's correct.
Now, was there sufficient quantity of blood that you would expect flaking off the socks at the time that they were taking off?
Sustained. Expertise.
Okay. Under what conditions, sir, will blood flake off of clothing, if you know?
Well, if you have, it kind of depends on the quantity. If you have let me take a step back again on that. By flaking off, I mean, you are going to have the potential of very small, minute quantities of blood falling off, which could be called flaking. Or if you have a very heavily stained item that has crusts of blood on it, then flaking could be visible chunks of the blood falling off.
Well, when you saw the socks, were there any visible chunks of blood of the kind that you just described that might fall off?
Sustained.
When did you see the socks, sir?
The first time I saw the socks was on June 29th, 1994.
Okay, and what did they have that kind of blood that was in sufficient chunks that you would expect it to flake off at that time?
No, they did not.
Now, when an item such as the socks is collected in the field, is the criminalist supposed to do a close physical examination of it prior to collection?
There's no rule that says that they have to do a close examination of any of the items they collect at the scene.
Would there be any reason to?
None other than maybe personal curiosity. If you have an item that you are collecting anyway, there would be no particular good reason to do a very minute examination of that item at the scene.
After you've already made a decision to collect the item, is there any reason from a forensic standpoint to inspect it any further in the scene?
Not in general. If there was some particular piece of information somebody was interested in deriving from them, maybe it would require a closer look. But once it's been decided to collect them, you're going to do that back at the laboratory.
Now, in terms of the removal of the bodies from the Bundy location, do you feel that a decision should have been made to wait until the criminalists had the opportunity to look at the area where the bodies were removed before they were removed?
Yes.
And how do you go about making that decision as to whether to allow the coroner in first or the criminalist in first?
Well, normally we like to get in and do our search, get our overall photos, to do our search and collect at least all the evidence right around the body or bodies prior to the coroner's arrival. Our concern is the total scene where theirs is the victim. and we like to get done as much as our work as possible so as to limit the amount of activity in and out around that evidence until it's collected.
So how are you balancing the need for them to do their work against the need for you to do your work?
Well, I mean, I'm looking at it from my perspective. From my perspective, the information that we get and the evidence that's surrounding the area is just as important or more so than what they may derive from the bodies at the scene. And I'm going to be protective of that and want to get my work done first before there's any chance of any sort of disruption or contamination caused by, there's a lot of handling involved when the coroner's office arrives.
So from your perspective, would it have been desirable to have waited even longer before allowing the coroner's people to have access to the bodies?
From my perspective, yes.
Now, we've had a lot of discussion about what Andrea Mazzola's exact job description and title is. Can you tell us what her title is?
She's a criminalist 1.
And is there such a category as a criminalist trainee?
No, there is not.
Do you use that term officially to designate a criminalist 1?
No, we do not.
And also there was a description of a mini academy. Are you familiar with that term?
The first time I heard mini academy was in this court. There is an SID academy, yes.
So you just refer to it as the academy?
Well, we refer to it as SID academy. It's a simple way of talking about training courses we have for new people.
Okay, but in terms of an academy, it's not a thing where you sleep in a dormitory style housing for a period of time, is it?
No, it's much more informal than that.
And at the mini academy, are the criminalists trained in how to do the physical collection techniques at a crime scene?
That's one of the things that are discussed.
And what other kinds of things come up at that mini academy, just in general? I'm sorry, academy.
Part of that set of training courses is to acquaint new people with what criminalistics is all about. The people that we hire many times are not fully acquainted with forensics, do not have prior forensic experience. So part of that process is teaching them what the other units are about, giving them an overall concept of what criminalistics is.
When you say that they all are not acquainted with criminalistics or forensics, does that mean that you're hiring some people that don't have degrees in criminalistics?
That's correct.
So what are their degrees in?
Well, the requirement for the position is a baccalaureate degree in a natural science. And we have many people that have degrees in chemistry, biology, biochemistry. I believe we have one in zoology, one in oceanography. We want people that are required that people have a degree in a science so that they've learned, basic scientific principles, the scientific method, and that type of thing. And then we train them within the laboratory about forensics.
Were you aware that Andrea Mazzola did have a degree in criminalistics?
Yes, I was.
And on the 13th of June, were you aware that Andrea Mazzola and Dennis Fung were processing the crime scenes at the Rockingham and Bundy locations?
Yes, I was.
Is it generally desirable to have more than 2 criminalists handling a given case in terms of collecting the evidence on a single day?
Have we covered this already?
Not with this witness.
We talked about having teams and the advantages and
But
listing documents.
more than 2. I haven't discussed that.
All right.
That's an issue that came up. I'll be very brief, and then I'm moving on to another area, Your Honor.
We'll be brief and then we're going to take a break.
Thank you.
2 is actually a fairly optimal number. I have done many scenes by myself, and I feel that that is not the best way to do it. I've done many scenes with 2 people, and that is great because you've got somebody working with you. You can bounce ideas off of each other, get assistance when it comes to taking notes, collecting the items. You actually do it quicker and I think better with 2. When you get past that into 3 and even 4, which would be excessive, you just have too many people in the scene. Many times the scenes of the crime that we go out to, the location of them is very limited, and you just start getting too many bodies in there. You start bumping into each other, and it's not as easy. So 2 is probably the best number to handle as a crime search team.
Thank you. Your Honor, I was now going to get into another area.
Ladies and gentlemen, we're going to take a recess at this point for 15 minutes. Please remember all of my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case. Don't allow anybody to communicate with you. Do not conduct any deliberations until the matter has been submitted to you. Mr. Matheson, you can step down. Your return in 15 minutes. We'll stand in recess for 15. Mr. Byrne, my research attorney, gave each party a photocopy of the handwritten 11-page list of evidence items in this matter. I did have Mrs. Robertson get the exhibits from the August Griffin hearing and August 94 Griffin hearing, and it does include a copy of this as item K. So the defense did mark that they did have access to it at that early time, so the record should be clear. And Mr. Blazer, you have a copy of that now before you? All right. Do you feel you need any additional time before we move into this item?
No.
All right. As to the second item, the board that the prosecution proposes to use regarding the defense testing of evidence items or taking those matters out of the prosecution's custody for their testing purposes, I'm going to ask the prosecution not to use that board this afternoon because I'm not comfortable with the state of my research at this point. All right, let's proceed.
Your Honor, there was one other issue that I wanted to bring up, and that was I wanted to make, I guess it would be a 402 type motion as to what extent Mr. Matheson will be allowed to discuss the issues of PCR typing and PCR type issues, which he is not testifying to in direct, except only extremely tangentially to the extent that evidence collection has some overlap to the issue of how a sample can be contaminated, that's subsequently going to be tested both conventionally and genetically. Specifically, there was an issue regarding some a lot, not a lot in number, but a lot as a discrete identifiable number of test kits that were provided to the Los Angeles Police Department by Roche Pharmaceutical some time before this case. I believe it was many months, in which there was a problem that was identified with the kits that I'm sure counsel probably intends to get into with perhaps other witnesses. But Mr. Matheson does not have any personal knowledge of that, nor has he read any documents, to my understanding, pertaining to that. So we would ask that they be precluded from getting into that area on cross-examination of the witness.
Well, having not heard anything about it yet, I'm loath to make any kind of a ruling on a basis that this is prematurely brought before the court.
Well,
If it exceeds the scope of the direct examination,
I'm sure the defense will come up with some reason that it's within the scope or necessary to cross-examine Mr. Matheson about it. I don't know.
I haven't heard it yet, so.
Your Honor, there's been plenty of questions about contamination, and that's directly on point in terms of contamination for later DNA testing. So I think it's already been raised.
Perhaps, but within the specifics of this witness's knowledge regarding PCR testing and the explicitly sensitive nature of that test, I don't know if he has the expertise to testify to that.
He's in charge of the lab.
I don't know. We'll see. We'll see. It's not here yet, guys. All right. Let's have the jurors. Let the record reflect we've been rejoined by all the members of our jury panel. Mr. Gregory Matheson is again on the witness stand undergoing direct examination by Mr. Goldberg. Good afternoon again, Mr. Matheson.
Good afternoon.
You were reminded, sir, you are still under oath, and Mr. Goldberg, you may continue with your direct examination.
Good afternoon, ladies and gentlemen. Mr. Matheson, I wanted to ask you some questions about the Scientific Investigations Division facility. Where is that located?
It's located in a city building called the Sierra and Piper Technical Building, or Piper Tech for short.
Your Honor, at this time I'd like to mark as People's Next in Order 206 for identification, which is a board that contains photographs and a map of the SID facility.
All right, People's 206. All right, Mr. Bancroft, I'm going to need you to help me with this. All right, proceed.
Sir, directing attention to People's 206 for identification. Do you recognize this exhibit and the photographs on it?
Yes, I do.
Is there any sort of accreditation agency that covers crime laboratories in the United States?
Yes, there is.
And is that a public entity or a private entity, or?
Well, it's a association made up of crime laboratories that have been accredited. It's called the ASCLD, American Society of Crime Laboratory Directors Laboratory.
But I mean, is that a governmental agency, or is it a private agency outside the government?
Well, it's not. My understanding is it's not a agency in and of itself. Most of the members of it are accredited laboratories, which are government.
Is it mandatory under state or federal law that you have that accreditation from this organization?
No, it is not. It's a voluntary process.
Does it cost money to become accredited?
Yes, it does.
How much?
Depends on the laboratory. The cost is associated with, it's actually associated with a couple of things. One of them is if there are any sort of facility changes or something, obviously the agency has to come up with the money to meet the accreditation standards, but just to apply, there is a fee associated with the inspection process. And my understanding is for an agency of our size, it could be anywhere from say $10,000 to $30,000.
So you would have to pay $10,000 to $30,000 to get this accreditation?
Yes.
And does it allow you to do anything that you can't do now?
No, it's just a review by this outside agency of whether or not we meet the standards that they've established.
Has the city come up with a $10,000 to $30,000 for you to be able to buy this accreditation?
Well, it's not a matter of buying the accreditation. It's paying for an inspection to see whether or not you pass. No, to this day, we have not received the funding to do that.
Now, turning your attention to this map that's 206 for identification, does this depict the Piper Tech portion of the SID, Scientific Investigations Division? The map.
Yes, the map itself covers the area that's part of SID at Piper Tech, yes.
And are there facilities that SID has that are outside of Piper Tech?
Yes, there is.
And are there photographs of the facilities that are outside of Piper Tech over here, if you look in the upper left-hand corner?
Yes, there's actually two photographs that depict part of our laboratory that's located inside of the Police Administrative Building or Parker Center.
That was where the old Dragnet series was filmed.
That's correct. At least it looks like that, yes.
Okay. Now, what is done, if you know, in the facility that's located at Parker Center?
The suite of 3 or 4 rooms that we have over there are part of our PCR laboratory.
And PCR is?
It's a technique used to identify DNA markers that are present in body fluids.
Now, you said that
samples.
you said that you did conventional testing on some of the evidence in this case.
That's correct.
And what facility did that take place in?
That testing all occurred in Piper Tech in the serology unit.
So that would represent, when we're talking about Piper Tech, the area that's depicted on the SID Piper Tech map on this exhibit 206.
That's correct.
Now, how old is the Los Angeles Police Department Scientific Investigations Division?
What about the crime laboratory has been in existence since 1923, I believe.
Was it the first crime laboratory that was set up in the country, to your knowledge?
Yes.
Even before the FBI?
Yes.
And how old is this physical plant?
I believe we moved here in February of 1990, I think, or 91. 90.
Okay. Now, do you have certain security procedures that are in place in terms of the physical plant located at the Piper Tech facility?
Yes, we do.
And who's in charge of that?
I'm the security manager of that facility.
Right. And specifically, do you have a card key system to get in and out of the facility?
Yes, we have. It's an electronic tracking system that you have to use a electronic card. It reads your card, determines whether or not you have access to a particular door at that time of day and that day of the week. If you do, then it unlocks the door for you and allows you to enter the facility or into the individual labs at that point. If you don't, the door remains locked.
Maybe we can see the photograph up on the Elmo that says card key entry. No.
Pick it upside down. Mr. Matheson, why don't you grab the pointer that's right there?
Well, I see it's a little lopsided, it's oriented up here on the Elmo, but why don't you just tell us, using the photograph that's actually on the hard copy, 206, what's depicted in that photograph?
But what we have here is a photograph that shows this is the door frame. Alongside here is somebody's hand that's holding one of our access cards in it. And there's an antenna inside of the wall. If you hold your card up in the vicinity of that antenna, it reads your card, reads the code that's on the card, checks the computer to determine whether or not you have access to that door that time of day, that day of the week.
And who has access to the crime laboratory?
The people that work in the facility, the access levels vary. It depends on whether we're talking about the outside entrance or the interior one or the variety of different labs. It's limited to the people that work in the facility or the other members of our crime laboratory that happen to work in some of the outside locations.
Okay, well, let's start with just if you want to get into the portion of the facility, maybe we can see the outside of the crime lab photograph. It says SID Piper Tech. We had it up there a little while ago. Okay, is this the outside of the facility?
Yes, it's the outside wall of the laboratory, which is within the larger building called Hypertech.
Okay, now do you need a card key entry to get through this door?
Not during normal working hours, which are Monday through Friday, from the morning until the evening. On weekends and at nights and in the very early morning, that door remains locked, and the only way you can get in is by having one of the card keys and having access to the facility at that time.
So who has the authority through these card keys to get into the facility, either in the evening or off hours?
But we do have some light duty police officers that work as couriers. They work in the AM hours, so they have access on getting in there. All of the criminalists can enter in the facility during through this outside door any time of the day and night. And we also have the opportunity to make temporary changes. Like sometimes our administrative staff, our support staff needs to get in to do some work on a weekend or something like that. We'll do a temporary change on their access so they can get in to work.
And does the call out line from that photograph indicate where this facade is located, the tiles?
Yeah, this particular wall is along this area here on the near where it says entrance. That's that door right there.
Okay. Now, after you get into the entrance, if you can see the area that says lobby.
Yes, right in this area here.
Can we see that photograph? Okay, then there's another door on the right side of the photograph and a window on the left. What is the door?
Okay, the door that's depicted on the right side of the photograph here is the door that actually goes into the hallway area of the laboratory. Like I mentioned before, this outside door unlocks and stays unlocked during what we consider our normal business hours, so anybody can come and go during that door. However, to get actually into the laboratory, you need to, again, show your card to an area so that the antenna can pick up the code, and then it'll allow you in if you have access to it.
And can the couriers go in there?
Yes, they can.
And what about the criminalists?
Yes.
All right. Now, after you're through that door, if you could see the picture that says entry corridor, does that show the view that you have after you've entered through that door?
That's correct. Right after walking through this door, that's your view down the hallway. You're looking down now in this direction.
And the hall's kind of in a square that goes around the facility.
Right there, the hallway. Once you get past here, anybody, once they pass through that door, has access to this hallway area. Then back over.
Okay, so when you're saying that door on the diagram, are you pointing to the door that's next to the call out, or that's just to the left of the call out line that's adjacent to photograph number 21 that says entry corridor?
That's correct. It's the door that's directly opposite the entrance into the lobby.
And when you said here, there's what appears to be a corridor, and it has various red crosses in it.
That's correct. There's a corridor that runs basically around the not the perimeter, but through the middle of the laboratory. You can walk all the way around without going back to this one point. Yes.
Now, other than the couriers, do any uniformed police officers have access to the corridor, the area past in the corridor that you just described?
The only other uniform officers that have a card key that gives them access into the laboratories, we do have one officer that works as a narcotics analyst within the laboratory. That would be most of the couriers.
Does he have a degree in criminalistics?
No, I believe his degree is in chemical engineering.
So he's actually working essentially as a criminalist in one of the laboratories.
That's correct.
So he is the only officer that has access to the corridor area other than the couriers?
That's correct.
What about detectives?
No, detectives would have to be escorted in or allowed into that corridor area
With the criminalist?
with the criminal or with other personnel that happen to have access to it.
Now, are there any windows in any part of this facility?
Not looking to the outside. The only windows that we have are from some of the laboratories into the hallway.
Now, let's take a look at the evidence processing room up in the upper right-hand corner of the photograph on the left side. What does that depict?
Okay, this picture marked SID EPR. EPR stands for Evidence Processing Room. Points to an area in the upper right-hand corner of the map here that's marked evidence room. This is the area where, when evidence is collected out in the field, it's brought into this room to be dried and then eventually identified, marked, and stored or prepared for storage.
And there appears to be a roll-up door in this photograph on the right-hand side. What's that?
That's correct. The right-hand side of the photograph here is a door that rolls up here, it rolls up towards the top, and it is this thinner line to the right of the evidence processing room 29B.
And the call-out line on that photograph depicts where the photograph is showing.
That's correct.
Now, that roll-out door, do you have to roll it up by going inside the evidence processing room?
Yes, the only way to roll it up is on the inside of the wall, next to the door between the storeroom and the evidence processing room, is a control button that says, I think, up, down, and stop or something like that. That's the only way that door can be opened.
And does the door to the evidence processing room itself, I guess it would be the door that is between the storeroom and the evidence processing room, is that also card key controlled?
Yes.
Now, who has access to this room?
The door that exists between the storeroom and the evidence processing room, all criminalists have access to that room 24 hours a day, 7 days a week, so that they can bring evidence in there. Other personnel, such as our lab technicians that we have in the laboratory and some of our student workers, have access to that room during normal working hours during the day, Monday through Friday. The support staff, clerical staff do not have access to that area.
So that the support staff do have access to the corridor area, don't they?
Yes, they do.
But they can't get into the evidence processing room through their card keys.
That's correct.
And what are the student workers?
Student workers, that's a position that we have. I believe we currently have 3 of them. They are people that have an interest in forensics or working towards their degree for eventually becoming a criminalist. The positions we currently have for them is we have 1 in toxicology, 1 in our trace unit, and 1 in serology. They assist the criminalists with like preparing some of the chemicals, whatever needs to be done that can free up the criminalist to do casework.
Now, in terms of the evidence processing room, can someone who has a card, well, with respect to any of the card key entry areas, can someone who has a card bring in someone who doesn't?
Yes.
And in the case of police officers, are police officers allowed into the evidence processing room?
Yes,
And if they were allowed in there, would they have to be accompanied by someone?
that's correct.
So they do not have a card to get into that portion of the facility either,
No, they would not be able to get in there without being escorted by somebody.
other than the one gentleman who's working as a chemist in the toxicology, did you say? Or
In our narcotics.
narcotics. All right. Let's take a look at the evidence control unit now. Okay, this is showing what? ECU lobby, the photograph.
The photograph that's marked ECU lobby, ECU stands for Evidence Control Unit. That is a property storage room that is actually run from within SID. The Los Angeles Police Department has property officers and we have a property division, but SID has our own property room of items that will probably be eventually analyzed, so they're very nearby and under our control. The picture that's depicted in marked ECU lobby is an area that is just off of the laboratory lobby. It's marked lobby on the map here. The only way to get to it is from the outside entrance through the criminalistics lobby and into the ECU lobby.
So when a police officer is coming to the laboratory to pick up evidence for court, where does he or she go?
They go into the ECU lobby. They can only, the front door is unlocked, so they can come in there. They pass through the criminalistics lobby into the ECU lobby, and there's a couple of windows where our property officers can interact with them, find out what evidence they need, and then they go back and get them and bring it forward to them.
And is that what they would do if they wanted to check out evidence that needed to be brought to court to be introduced?
Yes.
Now, let's take a look at the inside the ECU. Let's see if we have a good photograph of that. There's something that says ECU freezer. What does that depict?
Okay, the picture down here that's marked ECU freezer is a shot taken approximately what would be in this on the map. It's marked evidence control unit room 36, partway between the lobby and what's marked as freezer, looking in the direction towards the freezer. It shows the door, a very large freezer area where we store our biological evidence.
Now, who can actually come into the evidence control unit?
The access through the door that goes from the ECU lobby into the evidence control unit itself is limited to our property officers that actually work in that facility can come and go through there. The administrative staff of the crime laboratory, in other words, the captain that we have, and then the 3 directors have access to that. plus a couple of our supervisors also have access into it, such as the narcotics supervisor who has to check in and out narcotics a lot for analysis. It simplifies life for everybody for him to be able to get access to that area.
What about the criminalists?
The criminalists do not have access through that door unless somebody from that does have access allows them in.
Okay.
Now,
All
the
right. Enough,
person-
sir. Enough, sir. We did good today, guys. We really did. We're gonna get into the break room tomorrow because they did talk about the break room quite a few times. How it's the library and so yeah, we're gonna get into everything. Don't you worry, Josh, even though I know that was sarcasm. I understand that. I'm still answering it. All right. Guys, thank you so much for coming out today. I really appreciate it. And we shall see more tomorrow. I don't know if we're going to get to the defense questioning him tomorrow, but I hope we do because I can't wait. John, I've been on for 2 freaking hours. And I just got off another 2-hour stream. What are you trying to say? What does this comment mean? I want to know. I want to know. Should we just do OJ 24/7 till it's done? I am going to calculate in my head later how many days that would be if I did 24/7 OJ. Because that's me. All right, guys. Bye. Have a good day. See ya. Yo. Oh, you're good. John, you're good. I love you. Bye, guys.